This is a special meeting of the Providence City Plan Commission. Today is Thursday, May 7th, 2026. It is 5:31 p.m. We will call this meeting to order. Let's do a roll call.
Lindsay. Rachel Dotson.
Noel Sanchez.
Shire Manager Garden PD staff.
Megan DeSanto, legal counsel.
Bob Azar, DPD staff.
And I'm Michael Gasdacco, the chair. Do we have a director's report this meeting?
No, sir.
Okay. Then we will go right into the first agenda item, which is a minor land development project, a request for extension. It's case number 25-019 MIL 1107 Westminster Street. Yeah, we just take it. Oh, the mic's probably turned off. Sitting around.
Thank you, Mr. Chairman. I'm from the commission. My name is Joseph Baxter. Here on behalf of the applicant, 1107 Westminster LLC, and Mr. Federico, my member. We're here with a first of two possible violations on your extensions of the vesting period of preliminary plan approval, as provided for by state statute, draft policy 5/23/3988. The reason for the delay, there is an ongoing construction project, housing project directly next door to this development at 312 Knight Street, 321 Knight Street, which just created the possibility to stage both projects at the same time. There are also some delays to the development of my project, but he's able to have the best period extended for 1 year under the statute. That answer any questions that you.
Commissioners, do you have any questions about the applicant?
Just how long will that's the project that's Fountain's building on? Do we know how long it's going to take?
Are you sure? Do you have any insight as to the construction period for the swap building?
I'm not sure. I could certainly follow up through my clients. Get an idea from the other.
This,
I don't think it'll be done in a year.
I don't either. I thought that was probably a 24-month project.
Yeah, it's a pretty large.
Okay.
It just got started. Well, just got out. So what does that mean? You just come back once a year if you need another extension?
If need be, I also don't know if perhaps as the other project progresses, there might be an opportunity for staging control depending on the layout. I'm not sure of that, but I do suppose we could. Good construct.
Yeah, I mean, the expiration reads, just looking at the regulations. They have the authority to grant for more than.
Yeah, it says for good construct.
Where's the good but it doesn't actually say a year, right?
For a long.
If requested in writing.
Okay.
Show me what's the citation?
45/23/39. I'm in the statute.
Okay, so they could go longer.
It may be extended for a longer. Vesting may be extended for a longer period than 1 year for good cause shown if requested in writing by the applicant. By the planning board.
So you could go for 2 years if you want to.
I think you just put the written request that I
There it is.
submitted to the city planner for the first of two by right 1 year extensions. I believe the statute reads after those two thereafter further extensions will be granted.
Okay, so if you want to go for 1 year, then that's what he's asking for.
Do we open this one up to public comment? No. I didn't think so. So I guess we could entertain a motion to approve the extension.
I'll make the motion to approve the extension.
Okay. Do you have a second?
I'll second.
All in favor, say aye.
Aye.
Any opposed? Any abstentions? Good luck. Motion passes.
Thank you very much. Thank you.
Next up, city council referral, referral number 3614, regulations for entertainment. This is why we're here tonight for this special meeting.
Yes. Okay, I'll do a brief introduction of this one. So just an overview of how we regulate entertainment in the zoning ordinance. We essentially have a couple of different levels, and what's important to understand is that zoning sets the rules to allow for particular uses, but when it comes to entertainment, there are also rules around licenses. We have a board of licenses that issues things like liquor licenses, and they also issue entertainment licenses under there are state statutes that relate to how licenses are issued, what licenses are required, and so forth. So we have a couple of different categories of entertainment in the zoning ordinance. Excuse me. We have a couple of different categories, starting with sort of the least intensive, we have what's called incidental entertainment. And the reason this is in the ordinance is because we want to be able to have something that's allowed that doesn't necessarily require a license through the Board of Licenses. So we define incidental entertainment as background music provided at a bar or restaurant. It can be live music, but not more than 3 acoustic instruments, unamplified, pre-recorded music, just sort of background music played over a pre-existing a permanently installed sound system, and you can't have a cover charge. There's no dancing. There's no flashing lights, lasers, strobe lights. Basically, you're not there for the show. You're there for eating and drinking, and the entertainment is just something that's purely in the background. And that's specifically defined in the zoning. It's also defined in the state licensing law, and it's clear that the Providence Licensing Board does not issue entertainment for this type of entertainment. That definition is going to stay the way it is. Okay, there has been an effort lately to try to allow for just a little bit more leeway when it comes to entertainment at bars or restaurants. And so we have a new category that we're calling incidental entertainment expanded. It's still background music, but it could be live music performance, which can be amplified, as opposed to the prohibition on amplification of live music with incidental entertainment. It could include trivia and karaoke. Significantly, there could be some dancing, but you still can't charge a cover, and you still can't have flashing laser or strobe lights, and the volume, just like the other incidental entertainment, has to be contained within the premises. And importantly, this new incidental entertainment expanded has to cease 9 o'clock Sunday through Thursday and 11 o'clock on Friday and Saturday. Now, what's not written into this proposed zoning amendment is the fact that incidental entertainment expanded will require a license through the Board of Licenses. And the reason for that is that we are interested in having this kind of entertainment enforced through the Board of Licenses. They have their own police officers who go out in the field at night and can check to make sure that they are following the rules set forth in their license. If this only stayed in zoning and didn't require a license, then a violation would be a zoning violation. And zoning violations are enforced not by the Board of Licenses and the police, they're enforced by the Department of Inspection and Standards. These are the same people who go out to work sites and enforce the building code and the zone and other provisions of the zoning ordinance. They're not equipped to police these kinds of places at night. So it's really not, it's not a good fit to have entertainment being policed just by zoning. So that's incidental entertainment expanded. Then we have another type of entertainment, which we call live entertainment ancillary use. And that is even more intense than the two previous definitions that I just talked about. This could be, a full-blown show at a kind of a club setting. It's still supposed to be like in a bar or restaurant, but you could charge a cover. It could have a show, essentially, like people are coming there more for the show as opposed to these other two where they're coming for to say the restaurant, and this is happening in the background. Live entertainment ancillary use, you'll notice in the use matrix, is not allowed in any residential zone. It's not allowed in the C2 zone. It's currently allowed by special use permit in C3 and D1, special use in W2. It's allowed by right, you see the P's there, in the M1, MMU, and the I2 institutional zone. The proposal here is to change from special use to permitted by right in the C3 and the D1 zone. Importantly, just like incidental entertainment expanded, already live entertainment ancillary use does require an entertainment license. So we felt that, first of all, to require the purveyors of this entertainment to go to the zoning board to get a special use permit was kind of redundant if they're going to the licensing board, again, that has the more robust enforcement. Yeah. So, all right. So that's live entertainment ancillary use, and then finally, there's this last category of temporary entertainment. Right now, we call it temporary outdoor entertainment, and oddly, we don't have a separate use for temporary indoor entertainment. So we have a situation now where you have the ability to get a temporary use permit to do entertainment outside, but you can't do the same thing inside. So we are trying to correct that by calling this temporary entertainment, striking outdoor, and then revising the temporary use standards. So this does not, it no longer is going to require a zoning permission. Right now, it requires a temporary use permit. It won't require that anymore. But again, it will require a license from the Board of Licenses. And if it's outdoors and extends into the public right-of-way or otherwise into some kind of public space like a park, it's also going to need what's called a special events permit, where you need, a police presence to close down streets and things like that. So that's basically this ordinance in a nutshell. It opens up slightly what you can do in a bar and a restaurant as incidental entertainment, but subjects that new allowance to the entertainment license. it gives a little bit more leeway on live entertainment ancillary use in the C3 and D1 zones, but still under the purview of the licensing board, and it cleans up the provisions for temporary entertainment, now allowing temporary entertainment indoors as well as outdoors. So that's it. I'm happy to take any questions.
Commissioners, do you have questions about this change in text?
I have a question just for my own knowledge on the process for a business owner to receive a license for, I guess, the now temporary entertainment. So you said they don't need a temporary use permit, but they need to have a license. How does that?
Yeah, so for temporary entertainment, you'll notice in the use table that it's allowed in most places in the city. So, you know, this could be like a you know, the spring concert at a university quad, or a wedding at some kind of a restaurant or something like that. And this would be primarily in places where other types of entertainment wouldn't be allowed. And so we do have what's called a temporary use permit under zoning. That applies to things like, you know, temporary trailers on a site, more related to you know, things that can be inspected during the day, I guess. Having entertainment subject to special zoning review, the theme of this ordinance is to try to not do that, because it just doesn't, it's not a good fit in terms of when the zoning inspectors are out in the field. So the licensing board, which is another kind of quasi-judicial body that reviews applications for licenses, would be in charge of temporary entertainment. That is, I believe, not the case today. So it would be going from the jurisdiction of zoning to the jurisdiction of the licensing.
So the process to obtain this license, do they need monthly? I'm just trying to understand the burden on the person requesting
The previous one that it is a license from the Board of Licenses. It's just one bureaucratic.
Okay. All right. According to Megan, I stand corrected. They already do need the license from the Board of Licenses, but yes, they need at least monthly. I think sometimes, yeah, I think, and they can meet on a more frequent basis if necessary. We see sometimes that they, you know, if there's an emergency, if something happens.
They often have emergency
Yeah.
meetings when there are issues.
If I'm just trying to think, if you're someone that is having an event and you need permission, that you have to go in front of a different board to do that, is this more cumbersome for the applicant?
It's the same process that's already existed. It's just that you don't have to now also get the temporary use.
Yes, yeah, so yeah, it's easier to get in front of the license board than it is to get in front of the zone. For sure. And in my experience, they're the right body to be policing these types of uses. They already do with similar uses. They already do with these uses. It's just expanding their ability to do it and eliminating the special use permit, because as we know, zoning enforcement is difficult. It's not the right body to be policing these activities.
So in theory, we're maybe expanding opportunity for temporary or outdoor. But we also have mechanisms for better enforcement.
Yeah, I don't know that we're expanding the opportunity necessarily, but we're just sort of eliminating the need for a temporary use permit, which honestly it doesn't do much of anything.
So under the previous language, we weren't necessarily rejecting a lot of applications.
No,
Was it?
never, to my knowledge.
Okay.
Yeah, but the licensing board can, and can certainly revoke a license.
But they also have the ability to make sure.
They routinely inspect.
Okay, cool.
Well, with that. That was pretty much the staff report.
That's it. Yep.
So, this is a public meeting, so we'll take public comment. We'll also advise anyone speaking on this that we are acting, this is a referral from city council. So we're looking at the text, and how it relates to the zoning code. City council put this forward. City council will be having another meeting on Wednesday next week. And that's why we're here today, because they wanted to have this again on Wednesday of next week. So we're here to review it, and it'll go back before them next Wednesday. So with that,
I'll do them to that.
with that, we'll call the first person in our physical room. And if you're joining us virtually, please raise your virtual hand, which is in the bottom middle section of your screen, or press *9 to call it in. The first physical person to speak on this matter is Sharon Seal.
I would like to start by saying, or perhaps correcting, a fair amount of the information that was just provided about the board of licenses. Having testified hundreds of times before the board of licenses, they meet 3 days a week. They have enforcement in the way of supposedly 2 people. The most they ever have on a good day is 1.5. And they literally handle thousands of licenses. Okay, so if you all think that it is easy for them to go out and look at a restaurant that has moved their table and is operating like a nightclub, I am here to tell you they are busy dealing with stabbings, shootings, and real bad actors who know how to get away with things pretty easily. So that said, I guess I have several questions. This subject matter started on October 22nd of 2025. Do you all have all of the information as a result of the hearings that have happened on this matter since October 22nd of 2025? Because
so you're gonna, you,
it amounts to what I have to.
just like any other planning board hearing, you can state your questions, we'll write them down, and we'll respond accordingly.
So the questions go, start with this. Are you aware of a resolution that was passed as a result of the 125 people who attended the hearing on October 22nd? And the resolution starts with the creation of a working group. And I was one of people appointed. The mayor got 2 appointments, the council got 2 appointments. The first meeting was actually held on December 3rd. It was chaired by Rachel. It was attended by Justin Bryas, who is a council person from Ward 4. It was attended by Anthony Santuri, Lawrence the Coliseum, and Free Play Bar Arcade, who was appointed. I was there. And they had not yet appointed the number of people that were supposed to have been appointed. So that was the first meeting.
So, just to interrupt, 1 second. I'm not aware of that. I don't know if the other commissioners are. We're here to look at the text changes only. We're not creating this legislation, this is a referral from the city council. Apparently did this work group as well. We have no influence in that whatsoever. We're looking at specifically, and we can only speak to, and we're only going to listen to comments based on the text that we're looking at today, because that's all that's in our purview.
But based upon what I've heard, you are suggesting that there are certain people who are readily available to, shall we say, police, patrol, oversee things that you are suggesting that they are able to do. At least that's what I've heard. So I am suggesting perhaps that that is not the case, and that the recommendations that are being made are going to have substantial impact. And in fact, because the working group never literally was fully created and did the work that it was supposed to do, the work that it was supposed to do was in fact to do what you are now doing, because the working group didn't do that.
So this line of discussion seems very prudent at city council next Wednesday. This has nothing to do with what we're doing right now. I would love to hear your objections on the text of the ordinance that we're looking at right now, because the working group has nothing to do with what we're doing.
Okay, the reality is, based upon what the recommendations are, it would intensify what happens, right? So there is a step up from what is currently happening in the restaurant. And so what I am suggesting to you is that what is going to happen by the step up is that when you say that the sound can't permeate the boundaries, I am here to say to you, the sound does permeate boundaries unless you are talking acoustic, non-amplified music. It is impossible, literally, for that not to permeate the walls. And once it does that, it impacts the quality of life of everything that surrounds it. Okay? So, by allowing restaurants to basically function in many respects like nightclubs, but not have to have police details, increased presence. They can have a dance floor. They can have amplified music. There is no way that there are enough police, either now or ever, that will in fact be able to police that happening. And this can happen in restaurants in every neighborhood in the city of Providence. With respect to the stuff that's happening outside, where you are suggesting that that can be less restricted than it is now, we are already having problems. As an example, in District Park, and all of these people go before city services, right? And they have these licenses, and once again, there are not enough people to enforce it. So if you are recommending increases and we can't literally enforce what we have now, then I would say it is the definition of insanity, because if we are looking for a different outcome, there is no way that we can deliver a different outcome. And so I am imploring you not to do this. And the only reason we are here today at this special meeting is because Rachel realized that she had not done any of those things before she must literally come before ordinance next Wednesday. And we received a notice of this at 3:33 p.m. on Tuesday, which is the reason that nobody else could be here to see. If you have any questions, I will try to answer them.
No, thank you. Again, I suggest that you do attend the city council meeting, because I think most of your discussion points are very relevant to the discussion they'll be having there. And the next person in the room is Dylan Peacock. Yep. And then again, if you're joining us from the virtual room, please raise your virtual hand or press star 9.
Thank you so much for taking some time to listen to my comments relating to the Peacock. I'm also asking that the commission not recommend approval of these amendments. I actually have 6 pages of documentation on why this is not compatible with the comprehensive plan that I'll be happy to share. The comprehensive plan supports mixed use growth, and preservation of quality of life. Allowing live amplified entertainment by right removes the very discretionary review needed to protect residents as the city grows and preserve that quality of life. This is being presented as a minor refinement or streamlining. It is not. As State Senator Sam Bell explained in recent news articles, this one headline, "Shocking and appalling," says Senator. This is a major regulatory change. It allows amplified entertainment at all bars and restaurants across the city by right. This means it reviews review mechanisms that currently allow the city to ask whether a use is compatible with a particular location. That is critical for land use planning that this commission was charged with doing. And I want to be very clear, this isn't about whether Providence should support artists. Artists can already perform in restaurants. If you want to allow more opportunity, increase the number from 3 to 5, make it however many you like. There's a long-standing safeguard, and that is that those performances cannot be amplified. This is a common sense zoning solution that's pretty standard across all communities, and it's there to ensure balance between performance and neighborhood residents. It exists for a reason, it's put there for a reason. Amplification is what allows sound to leave the premises and turn a restaurant into something closer to a nightclub in practice, which is not in compliance with a comprehensive plan. Nor is this necessary for economic competitiveness. Now, mind you, these are 2 points that are noted in the staff reports of why the sorry.
I want to correct you. You're making non-factual statements.
Can you please, please.
Because you're saying that all of these are allowed by right. The use might be allowed by right, but there is a license required. That is the mechanism. So
believe
it
it
is.
Maybe it was a typo in the text there, it said in the text that incidental entertainment.
So incidental entertainment is no license. Incidental entertainment expanded is required to go in front of the licensing board.
But it said in that
require a license.
red section, I believe I saw the word by right.
No, it's been taken out.
It's been taken out, okay, I must have looked at it.
Yeah, it is
Well,
not.
Well, I'm sorry, just to clarify, Mr. Chair. From a zoning perspective, it's permitted by right, and I do say that in the staff report. But yeah, to be clear, the licensing board has purview that zoning doesn't have, and so while it's by right or zoning, it could be stopped in its tracks at the licensing.
What authority would the licensing board have though to stop it if it's allowed by right now?
No. It's just like a liquor license or any other operational license.
So when somebody goes before the licensing board for a liquor license, I've seen this happen many times. The licensing board says we cannot deny this because it is allowed by right. So that's an important distinction. If that's not the intent here, then that has to be.
Well, it's true.
Yes, please.
Yeah. So yeah. So if somebody, let's say that the zoning allows something. Somebody wants to have a bar wants to have somebody who is singing and playing the piano or playing the guitar, and the singer wants to use a microphone and wants to amplify, say, an electric guitar or an acoustic guitar. It doesn't matter what the volume level is. That cannot, by definition, be incidental entertainment. It will fall under the definition of incidental entertainment expanded. My sense is that the licensing board, unless the licensing board has a good reason to deny that entertainment license, they'll grant it. But then the license is enforceable if the establishment isn't abiding by the conditions of the license.
So it is allowed by right then.
It's allowed with a license.
The license, just like a liquor license, if
I-
it's zoned for a location that allows.
Yeah, I mean, the
Just like
whole,
with an I'm sorry, I just wanna finish my question. So just like with an existing liquor license where the board has to grant it by right, automatically up front, despite neighbor objections. They cannot, if neighbors object to a liquor license being granted, they have to grant it.
Okay,
And it's the same, I'm just saying, this is an important thing.
continue on your,
Okay.
on your path.
So I attended numerous comprehensive plan meetings, noise from businesses came up repeatedly in the discussion on those little post-it note boards. And for residents trying to explain exactly what happens when commercial noise is not controlled. I personally met with Bob Azar at the Career Technical Academy at a public event. Because the property behind us was being upzoned from C1 to C2, and I was assured that the city understood the need to balance upzoning actually for residents and that entertainment would not be allowed in C2 zones. But now that same upzoning is being paired with entertainment deregulation, and that creates the conflict that residents were worried about. Importantly related to the comprehensive plan, objective LU4 directs Providence to use zoning tools to ensure that adjacent land uses are compatible and do not negatively impact each other. These amendments do the opposite. They remove important zoning tools, oversight, and enforcement mechanisms. For example, with temporary entertainment, what was not disclosed is that the amendment directly removes the existing language requiring the city to evaluate parcel size, parking, traffic access, and the absence of undue adverse impact, including noise on other properties. How is deleting that language consistent with objective LU4? Who does that serve, and how is that in the public interest, removal of that language? The city may say that residents are protected because sound cannot permeate beyond the walls or boundaries of the premises, but in practice, that protection exists mostly on paper. Enforcement depends entirely on Providence police. They are understaffed. In 2022, there were more than 5,500 noise complaints and only 19 citations issued. In 2023, there were roughly 5,600 complaints and 163 citations. That is not a system that provides meaningful relief to residents. The failure of this enforcement system right now is measurable. And I know because I lived it. To Bob Azar's point about the enforcement of the Board of Licenses, it took me 10 years, hundreds of police calls, dozens of Board of Licenses hearings, and 4 hearings before the State Department of Business Regulation to get relief. That is actually what the current system looks like in practice. That's not, and there are so many across the city that have had the same experience. These amendments would make that worse through fewer defenses for neighbors, less public oversight, more burden on residents, and more reliance on after the fact enforcement that clearly does not work. The impact will also not fall this is my thought. Commercial corridors disproportionately run through lower income communities, like Elm. The east side, which is almost entirely residential zone relative to the rest of the city. Bars and restaurants sit directly beside homes where people are the least likely able to defend their own rights. And wealthy areas with more instability. Loosening these rules strips protection from residents already overexposed to noise and underprotected by enforcement. This is an equity issue, and that is another objective of the comprehensive plan. At minimum, amplification should be removed from by right incidental expanded entity. Licensing should not become a backdoor for nightclub or entertainment venue uses. This is making a lot of confusion within zoning on how, what exactly is the meaningful difference between a nightclub and a business that is allowed to use this? How will that actually be enforced in practice? So residents, the growing city needs clear compatibility rules, through protection. Again, 6 pages on why this is not compatible with the comp plan, and I have another 4 pages of language you can just copy and paste into the ordinance to make it compatible with the comp. Thank you.
Thank you. Is there anyone visiting us in the virtual room who wishes to speak on this matter? Again, if you're joining us, press *9 if you're calling in, or raise your virtual hand in the bottom middle portion of the screen.
There's nobody online.
Well, I do feel bad for people who have issues with enforcement. I know that the zoning board is not going to enforce things any better than the licensing board. In fact, they won't enforce it at all. In regards to evenings and things like that. The incidental entertainment expanded. I think there's a view that this is going to be a nightclub, but you can't charge a cover, you can't employ flashing lasers, strobe lights, maximum volume. It's limited to the boundaries of the premises, and it has to end at 9 p.m. on weekdays and 11 p.m. on Friday and Saturday. That's not normally a definition of a nightclub. I don't know how the other commissioners feel about that. That's not how I perceive the nightclub. And then the other text changes, I again, they make absolute sense to me, but
For the 5,000 and odd some complaints, do we know that those came from establishments with music, or were they track? Because like
we don't
probably
know
a
it.
thousand of them,
I don't know.
probably 1,000 of them were from me complaining about neighbors in a residential zone.
yeah, but if I didn't make it clear previously, we closed the public comment portion of this agenda. I apologize. No, we don't have that data. That wasn't data that we derived. It was given to us just now, so we don't have any.
There's a difference between C2 and C3, right? And so how does this affect the C2 zoning?
Yeah, so this affects bars and restaurants that are allowed within the C2 zone. Today, they are allowed to have incidental entertainment. If this passes, they will also be allowed to have the incidental entertainment expanded. But they would have to apply for an entertainment license to get that.
And right now, they don't have to apply for an entertainment.
They don't have to apply for an entertainment license to get incidental entertainment. That would be the case going forward. But again, incidental entertainment is more restrictive than this expanded version.
So right now, they're not allowed to have live music amplified.
That's right. That's right.
Do we have maps available to just see where C2, what is surrounding, how many people are?
Sure, I can pull up the zoning map and just kind of show you. Yes, so on the zoning map, let me maybe turn off the aerial photos, maybe I'll make this transparent, less transparent. So you can see that the C2 is this color that, that corresponds with parts of Smith Street. This is Douglas Avenue. This is north. There is C2 on the east side. This is North Main Street. This is Hope Street near Rochambeau, Wayland Square, Wickenden Street, Gano, Ives, and then of course, like Apples Avenue, parts of Broadway, and so forth. So it tends to be what you might think of as, and the way the comprehensive plan describes it, as neighborhood commercial corridors. The C3, where the live entertainment ancillary use is proposed to be allowed by right, is the darker red, and then downtown, of course, is right here. So I think what this is about is, should your neighborhood restaurant or bar be allowed to have amplified live music indoors?
If this were to go in front of city council, would they make an assessment, or if this is going in council, would they determine if there needed to be more hiring to, like, the switches to licensing? Would that be part of that discussion? Only 1.5 people.
Well, certainly that would be something that they would take into consideration as they review this.
They passed the budget.
So maybe that's a recommendation. Is staffing, if they're gonna take on more work, is staffing appropriate?
I think we know what we're gonna have.
I don't have any visibility of that. Yeah.
I can't speak to much except to say that I am aware that staffing needs were considered when this ordinance was put together by the administration and the council.
Where in the language is it suggesting that we now add C2 where it wasn't?
Okay, so if you look at on the first page, the table 12-1, the use matrix, that little table that has, it's an excerpt from the use table. And this is, I mean, the thrust of the discussion that we've been having relates to this incidental entertainment expanded. That doesn't appear in the table. What does appear in the table is the two other types of entertainment: live entertainment, ancillary use, and temporary entertainment. And with respect to temporary entertainment, the only thing we're doing in the table is striking the word outdoor. And for live entertainment, ancillary use, the two changes are in the C3 and the D1 column, where the proposal is to go from special use to permitted. So again, for live entertainment ancillary use, this is not even allowed in a C2 zone. This would only be allowed in C3, D1, W2, M1, MMU. These are much more intensive zones. But again, what the proposal is that they would no longer have to go to the zoning board. They do today, and they still would be required to go to the licensing board. But I don't know that, I mean, I don't know how controversial that proposal is. It just, it's just one fewer step, and it was, you still have to get a license. I think that, the point behind this is that we want all entertainment except for the least intense to get an entertainment license.
And the least intent isn't changing at all.
That's right.
I'm just listening to public comment, and I believe that what I understood was people in a C2 zone would now be subject to different regulations or rules than they would have been if this wasn't passed, and I don't see anything on this paperwork that speaks to that, so I just wanna make sure that I'm understanding.
Okay, so we have a use table that describes dozens of different kinds of uses and where they're allowed. Incidental entertainment is not a use per se. It's something that is allowed to happen within a category of use. And the way we do that is the first thing is we define incidental entertainment at the beginning. We don't define it as a use, we just define it as a term that's used in the ordinance. And then in the use table, there's it shows you where bars and restaurants are allowed. So for example, bar is allowed in C2, C3, D1, W2, etc. And then when you go to the definition of bar, what's called the use definition of bar. Bear with me. We say at the end of that definition, incidental entertainment shall be a permissible accessory use within a bar. And then again, the definition of restaurant, we say the same thing for a restaurant. Okay, so wherever a bar is allowed, incidental entertainment is allowed. And wherever a restaurant is allowed, incidental entertainment is allowed.
And that's not changing.
And that's not changing now. Maybe this is something that Megan and I should talk about, is that within those two definitions for this, that we should probably say incidental entertainment and incidental entertainment expanded. So that's actually a good point. I think that probably needs to be clarified.
Yeah, probably.
That should be part of the recommendation.
Yes,
Yes.
definitely.
But, right now, a bar doesn't have the ability to have. I'm not gonna say karaoke, because who really wants to go to a bar and listen to karaoke? Trivia. I like trivia nights.
No, people like karaoke.
People like karaoke, yes.
Yeah, and by the way, you can't have karaoke or trivia or that sort of thing at a bar or restaurant in the C2 zone right now because it's amplified. Someone picks up a microphone at a bar or restaurant in C2, not allowed.
If I could, my understanding from this is that it's also trying to codify what is really happening on the ground. There's a lot of this actually happening without it being permissible by zoning. So this is a way to align our zoning ordinance with what is really happening in bars and restaurants. And because it's not allowed, but it's happening, we're actually limited in our enforcement ability. So our only thing we could do is something very draconian, like take away their liquor license, which is very heavily regulated, and we probably don't have the right to do that. So it actually sort of is like an acknowledgement of what's really happening, and then a drawback. Has to end at 9, can't be heard outside the premises, needs a license. So instead of it sort of happening in a way that's illegal and then kind of our enforcement is actually more limited because there's no legal avenue to license it or set standards. That's my understanding, is that this is happening. And we're kind of hand-tied in our ability because it's like whack-a-mole. Whereas this will set standards, be a reflection of what's really happening, but give us mechanisms to really clearly regulate it by licensing.
And then a repeat offender who's applying for license would, like, it's all staying under the same umbrella.
My understanding, it's not part of this ordinance and it's not really within my purview, but my understanding is they're looking for an annual license. So as much as there are concerns about enforcement and maybe it wouldn't be immediate, if there had been a history of enforcement issues when it comes back up,
Right.
like that would be a very solid basis to not renew.
Right. And then rather having some, oddball police records that maybe aren't accessed at the time of license renewal, it would all be under the same umbrella, right?
Right. The idea of this is to be able to it's sort of a dual liberation with more control, right? So an ability to have more control over it, and have very clear rules.
Yeah, I think the clarification of the text where incidental entertainment, making sure that they add in the incidental expanded should be part of the
Yes.
the recommendation, whatever we recommend.
So from a citizen or neighbor perspective, what recourse is what changes in the recourse? I mean, I relate to the situation. I had a club across the street from my house. We were trying to get a liquor license. It was bad enough without a liquor license. It didn't have zoning for a lot of them. Then we did go to the licensing board. The police record was inaccurate. There had never been a call. I call them every weekend for a year. So the police record was not accurate on that. At least the way I saw it. I hadn't probably used the right address. Told them where it was on the corner. They needed a number on the house. It's like, well, sorry, I didn't know that you had to do that. So my question is so if the zoning at that, if the recourse at that point was to go to the zoning board and ask, can you zone this house different or this property different? That was really possible. Going to the licensing board wasn't easy either. They kind of get heard. So does this increase, or is there a place to increase the recourse for the citizen who is in, living next door to a place where this is going to happen? Or is there a way to add something like that?
So just for clarification, the only change for zoning where there was a special use permit previously required in C3 and D1 is for live entertainment ancillary use. And I don't think that's what most people here have been talking about. The majority of the discussions we've heard today was about the incidental entertainment expanded.
Which is going to allow live amplification.
There is no change to the zoning tables for that whatsoever.
Right. So, but it's going to allow amplification in a bar,
Yes.
or restaurant that could be in a neighbor,
Yes, absolutely. Yes.
And so, so my question about that is then, so from a not from an enforcement perspective, but from a complaint perspective, I guess, is there a place to go, or will it still be, well, just possible to go for the best? Or am I gonna have to go to, so I know I had to go to the licensing board, we kind of prepared to go to that. Anyway, that's like, I don't know if the questions.
So my understanding is that there will be a companion ordinance that will be adopted with respect to this, that will govern the way the licensing board deals with these licenses. And that will have to be adopted along with this. We don't have that language, but there will be specific regulations for incidental entertainment expanded.
Right, but you're saying we won't get to see that in here,
We never would have
yeah,
before.
right, and so,
Nor would the zoning board have seen that before. The zoning board before would only have seen an appeal after a violation was issued. I've never seen one.
yeah. No, so I think my question is about access for the neighbors or for the citizens, you know, people who are gonna be affected, this.
I think if
And
you
if
had a
it's-
complaint, it wouldn't be to go to the zoning board.
No, so then not, but you said there's gonna be a companion ordinance going out with this one. To improve the other side of the point, which would be the enforcement, I suppose, right there. And so, I mean, we could at least say that if we recommend the changes, that we also would
That we
like to see them, the other one go with it.
a complaint mechanism, enforcement mechanism, and appropriate staffing for enforcement. I think those would be all
Right.
absolutely rational suggestions to have to the city council. Staffing and funding for, you know, the licensing board. Because they're gonna need to pay people to do this if they don't already.
Yeah.
So yeah, so that it would be, I mean, I think that is,
So I agree that it does happen already, right, and it's happening in the live entertainment with amplification, it's not loud or something, maybe most of the time. But there's sometimes, well, a lot of times I suppose it is happening without it being interfering, with other people. That part would become regulated, which may make enforcement a little bit easier on the other.
I think that's the point.
yeah. And again, this is the city council's going to have to figure out how to put this ordinance into effect, and that's where the rubber's going to meet the road. But I think giving a positive recommendation with the strong suggestion of adding some sort of complaint mechanism, enforcement mechanism, and the appropriate staffing and funding for the Board of Licenses to enforce all of these regulations, the entertainment regulations, along with the clarification of the text where incidental entertainment to include incidental entertainment expanded. I think that's a good motion for this one.
I have no thing to
Mhm.
add. That's it. So one of the changes that have been suggested would be outdoor entertainment being changed to temporary, is that the applicant would be able to, was limited to 3 events, and now it's 9 events per calendar year, which seems like a huge increase. If we're already having a hard time with compliance, that is the why the people, I feel like we're giving them more lenient, them being small business owners that are having these events, we're giving them a little bit not more leniency, but we're making it more streamlined, with the goal being it's easier for us to police, so to speak. But if we're tripling the number of events when we already have a hard time policing it, should we look at that? And is there any reason why it's been suggested to be tripled?
Yeah, I don't know the rationale for that. I don't know if there are any complaints about that. I mean, this is, you know, like what we were discussing was weddings and things like that happen with a license. They need to have a minimum of 30 days between each event. That hasn't changed.
Right, that's true.
So it's not like they can have more than one a month. It can't be just like every weekend you're bombarded by this.
Right.
I don't know if that offends me. I don't know the reason for it. But it doesn't seem like it's unreasonable. I mean, they're not moving it to 12, so you can have one every month. They're still saying, you know.
Is it maybe a sidebar to the recommendations would be like a limit of like the counting of complaints, or like if an offender racks up a certain number, is there an automatic action or rejection of applications for licenses? Until, like, I'm just wondering if there's some,
Each one of these temporary entertainment would have to be a special a license, a separate license.
It sounds like what Rachel is asking is more related to
it's
in any of the types of entertainment. And whether a certain number of complaints would trigger some kind of enforcement action. I mean, I think certainly the complaints would have to be verified. And that's
coming from the licensing.
Yeah.
board, the amount of events they're having maybe doesn't matter as long as they're always in compliance.
Yes.
But if they've been
Yeah.
found to be out of compliance 3 out of the 4 events, then that needs to be part of their application
Yeah.
for the year coming.
So the chair had already discussed that there would need to be a complaint mechanism and enforcement mechanism, and perhaps you could say that the enforcement mechanism is should be tied to the number. I don't know how you'd say it.
To future
Like, is there a limit of complaints that are acceptable, and then once we get over that?
Yeah.
to
I'd be careful about just the number of complaints in case you have somebody who's just being spiteful, but you know, certainly verified violations.
but something along those lines to make sure that, like, for these temporary outdoor entertainment or temporary entertainment, indoor, outdoor now, because we've never had an indoor. That they're gonna have to come back every time they have one of these, so they could be there in front of the board of licenses 9 times a year.
Right.
If after the 6th one, they have 25 complaints about the last
Right, or
couple,
2 registered
that's what
violations.
we need.
Yeah.
We want them to take that into consideration, to make sure they don't
Right.
just keep issuing these because they say they're up to 9. That they take that into account, but there could be someone who's having like 9 weddings a year in this, yard that has no issues whatsoever. So I wouldn't want to like hamstring someone.
If you're listening to a live saxophone or a DJ playing 45s that has amplification, doesn't matter as long as it's not exceeding the.
Can anyone verify if there is any actual, there's credibility to the public comment that if you are given the use by right, that regardless of going in front of the licensing board, they can't deny it? That was
That'd
what
be-
I took away from that.
Megan
I feel
would be
like
the
why would
best
they
to-
pick the licensing board if that were the case, but I'm just curious as to.
That's not my understanding. My understanding is the licensing board has discretion, but I don't do licensing. I do know that liquor licensing and is sort of its own animal and its own beast, and it's regulated by the Department of Business Regulation and has its own set. So I don't believe that the liquor I know that the liquor licensing and entertainment licensing are 2 separate things, and what might apply to liquor licensing doesn't necessarily apply to entertainment licensing. I'm not aware that the licensing board is there to just rubber stamp everything. My understanding is it has discretion.
I wouldn't be questioning it otherwise, but I feel like if we're saying this is allowed with the suggestion of enforcement and an applicant coming in front of the board, if there is no one really holding their feet to the fire because you just get it by right, then our suggestions are moot. I don't know how to, I mean, the licensing board operates how it operates regardless of our suggestion, but I just am now curious as to if it really is just by right, you show up and you get your license because you're in the right place.
I mean, our suggestions are our suggestions to the city council also, and they may take them or not. They're suggestions. We are recommending, and then they will do what they please based on their own feelings. So I feel like this is something that they want. We're going to recommend safeguards the best way possible to make sure that it's the best for the people of Providence.
Also, if I could just clarify, again, I don't know a lot about licensing, so it's probably not the best question for me, but it is not the case that everyone who comes for a liquor license is entitled to a liquor license. I know for a fact there are quotas. A municipality is only allowed to give out a certain number of liquor licenses and it's all regulated, so, I mean, that, the quotas by themselves are a bar to the idea that every single applicant who comes forward seeking a liquor license may obtain one.
Okay. So we have, as drafted with the suggestion, the added suggestions of the clarification of the text where the incidental and the incidental expanded speak to the complaint mechanism, the enforcement mechanism, the staffing and funding for such mechanism, and then the ability to look at the track record of the applicant, especially for temporary permits when they're coming time and time again. Is there anything else that we should be adding to this, or does anyone have a motion? If someone could simply say so moved. All right, do we have a second?
I'll second.
All right, we'll do a voice vote, just all in favor, say aye. Aye.
Aye.
Any opposed? Any abstentions? Okay. We will pass that recommendation with the added safeguards onto the city council, and they will hear it next Wednesday and act accordingly. I would entertain a motion to adjourn.
So moved.
And a second.
I'll second.
All right, thank you very much.
Thank you.
Where, let's see.
Is it the ordinance